The Illinois State Constitution, Article 2, the powers of the state. Article 2 declares some principles regarding the powers of the state government and of its parts in relation to one another. These fundamental principles had long established in American Illinois constitutional law, but are stated in the Illinois Constitution for the sake of completeness. No, for the sake of you knowing this is the law. Section 1, separation of powers. The legislative, executive, and judicial branches are separate. No branch shall exercise powers properly belonging to another. The basic principle of separation of powers has existed in the governments of the United States and all the states from the earliest times. Illinois courts have often said that it does not prohibit all exercises by one branch of the kinds of powers usually found in other branches. In General Assembly, exercise judicial-type powers if it holds a witness in contempt or impeaches and convicts a state officer. The court exercise legislative-type powers if they withdraw legislative districts after other bodies have failed to do so. And administrative agencies in the executive branch often exercise 2 or even 3 kinds of powers, subject to judicial review for legality and procedural fairness. But separation of powers prohibits any of the 3 branches from coercing or controlling the actions of another. Delegation of legislative powers to other branches. The Illinois Supreme Court has held invalid a law attempting to authorize the State Department of Public Aid, which the governor consent to reallocate appropriate funds among aid programs of the department, since that was an attempt to delegate legislative powers to the executive branch. The Illinois Supreme Court in 1994 also held that this section was violated by legislative delegation to courts of responsibility to decide whether an automobile maker could allow a new dealership in the market area of an existing dealership. The law essentially required courts to make policy decisions on whether to allow local competition and automobile retailing. On the other hand, the Supreme Court in 1983 upheld a series of actions in which the General Assembly authorized the governor to reserve some state funds from spending to establish a financial reserve, and the Department of Public Aid reduced spending to temporary halting reimbursement under the Medicaid program for the medically indigent person not eligible for medical due to membership in a category such as dependent children, but unable to afford the entire cost of their medical care. The aid to the medically indigent program was later abolished by statute. And I believe that was against the Native or Indigenous people, Native Americans or Indigenous people of the United States of America, who we call Native Americans or Indians, yes. And they are part of their own nation, but they live among we the people. And your Federation talks about that, which is your Constitution of the United States of America. And yes, Illinois Constitution talks about it in its preamble. You are to be domestically tranquil. And your Federation says not to be domestic violent. Encroachment by legislator on other branches. The Illinois Supreme Court has held invalid a number of laws that it said encroached on the powers of the judiciary. Examples are given in the discussion of Article 6, Section 1. The Supreme Court also held that this section is violated if a law enacted by the General Assembly attempts to overrule the court's interpretation of an earlier law as to case that arose before enactment of the amendatory law. Particular cases that have been finally decided by the courts before the new law takes effect. And the Attorney General advised that a proposal for a legislative commission to exercise control over the spending of funds after they were appropriated would be an unconstitutional encroachment by the legislative branch on the executive powers. Delegation of governmental powers to private group. Although not stated in the section, it is a well-established constitutional principle that governmental powers may not be delegated to a private group. Section 2, powers of government. The enumeration in this Constitution of specified powers and functions shall not be construed as a limitation of powers of state government. The provision new in the 1970 Constitution declares that the Constitution does not grant powers where none existed before, but merely sets limits on powers that are inherent in the state government. This principle had already been recognized by the Illinois Supreme Court, unlike the national government, which has only the powers that are set forth in the U.S. Constitution or are needed to execute those powers. The state government has all the powers not denied it by the United States or Illinois Constitution. So, may God give Illinois and Illinoisans and we the people of the United States of America wisdom as they comprehend and ponder these things. Peace, 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 peace.